Well, good morning. My name is Leah Njoroge, and I thank the organizing committee for inviting ICSID to participate in this year's conference. And I wanted to say congratulations for reaching this 10-year milestone. We celebrate you for bringing the best minds in international arbitration in Africa year after year, and can't wait for what's in store for the next decade. Well, I've been asked to speak about enforcement of BIT awards against states, and in my presentation, I will focus on the ICSID arbitration enforcement regime. But before we look at that, I'll give you some background on ICSID and its work. And then first of all, I will recall some of the characteristics of the ICSID system and examine them from ICSID's convention regime for enforcement of awards. So who is ICSID? ICSID is, there are 5 separate arms of the World Bank, each with a different role and staff. ICSID is the smallest of these groups. Its operations are completely separate from the rest of the World Bank, and it is the only non-financial arm of the World Bank. It is wholly devoted to the resolution of investment disputes. I wanted to say here that African states have had a long record of participation at ICSID, and the latest member to ratify the ICSID convention is Angola in September of last year. So moving on to the next slide on the characteristics of the ICSID system. There are certain special features that make ICSID particularly advantageous for investor-state dispute resolution. And I'll state some of these features here. And one is that ICSID is an impartial and autonomous institution. What this means is that the main advantage is that there is an existing impartiality that comes with using ICSID arbitration. This means that it's not attached to any state judicial system, be it the respondent state or the investor state. So that takes the nationality issue out of the equation and strengthens confidence in the dispute settlement mechanism. The second feature of ICSID arbitration is that there's a balance between the interests of host states and investors. What this means is that ICSID was designed to maintain a balance between the interests of host states, and this is reflected particularly by the possibility of investors to bring claims that they have against states to ICSID. And I may also say vice versa, although it's very rare, but states themselves can bring a claim against investors. And the third thing about ICSID arbitration is procedural efficiency. ICSID has strived to continually improve efficiency of its procedure and has shown leadership in this area. Particularly, I'll draw you to the new ICSID 2022 rules, which have have codified some of these procedural efficiency mechanisms. The fourth point is that there is access to a global network. ICSID relies on a global network of the 120 offices of the World Bank Group, and we have more than 20 partner institutions, so you can have your hearing wherever it is in the world. The fifth thing is that we have the expertise. ICSID has administered over 70% of the known ISDS cases. We provide assistance to parties, to tribunals, and throughout all the proceedings, ICSID is the only institution that can administer cases under the 3 main rules, that is ICSID, ICSID Additional Facility, and UNCITRAL. ICSID has also been designated as a secretariat under the CETA Treaty and the EU-Vietnam. The next slide, I will drill down to the autonomous feature of the ICSID system. And in particular here, I want to mention that the ICSID system has been described as being self-contained. It has its own post-award remedies. There is no appeal against decision and awards of ICSID tribunals to state courts. And this particular feature makes ICSID very unique and is one of the fundamental features of the system. There are a limited number of post-award remedies, and there are 4 of them which appear in the convention. So the first one is supplementary decision and revision. And if a party believes that the tribunal has omitted to decide on something, or it wants a rectification of a clerical error or an arithmetic error, particularly on interest, it may request a supplementary decision. And the second type of post-award remedy that you can find in ICSID arbitration is interpretation. And here, if this happens when there's a dispute between the parties as to the meaning and scope of the tribunal's award, and either party may request an interpretation of the award. The third type of remedy is revision. If this happens when there is a new fact that comes to light that would affect the tribunal's decision. And this, the new fact must have been unknown to the tribunal at the time and the applicant when the award was rendered. So the applicant's ignorance of that fact cannot be due to negligence. And the fourth type of remedy that you can have is annulment. And there are only 5 limited grounds for annulment. And I wanted to mention here that an annulment is not an appeal, but it is an exceptional recourse to safeguard against the violation of fundamental legal principles relating to the process. And this is governed especially by Article 52 of the ICSID Convention. And the 5 limited grounds that have been governed under Article 52 are that the tribunal was not properly constituted, the tribunal manifestly exceeded its powers, there was corruption on the part of the member of the tribunal, there has been a serious departure from a fundamental rule of procedure, and finally, that the award failed to state the reasons on which it is based. So after looking at this autonomous feature, the next slide I want to look at what are the existing recognition and enforcement mechanisms in ICSID. As I said, the ICSID Convention has a simplified recognition and enforcement mechanism due to its self-contained nature. So an award rendered under the Convention is binding between the parties to the dispute and not subject to any appeal, and this is in Article 53 of the Convention. So the obligation to comply with the award arises once the award is rendered, that is, on the date on which the certified copies are dispatched. Each party must abide by and comply with the terms of the award except to the extent that the enforcement is stayed pursuant to the Convention. This means that a state would not be in breach of the obligation to comply if it has initiated its challenge under one of the recognized legal means. Under the ICSID Convention, the period for which a state would not be responsible on the ground of delay of non-compliance would be until the period of time commencing the annulment proceedings has expired, that is 120 days, or if the proceedings are commenced until they were completed, provided a stay of enforcement is granted by the annulment committee. So each of the 150 contracting states must recognize the award as binding and enforce any pecuniary obligations within the territory. And here, the key element is that it must treat the award as equal to a final judgment of its domestic court. And this is in Article 54 of the Convention. So a party seeking recognition and enforcement should ideally only furnish a certified copy of the award to the competent domestic court. And once the recognition and enforcement step has been made, the next step is execution of the award. And this is governed by the laws of execution of judgments in the state in which execution is sought. And these may include laws relating to sovereign immunity. In many cases where states have resisted enforcement, they have done so and relied on sovereign immunity as a defense. And here, one case in particular I wanted to look at is the AIG Capital Partners Inc. and another versus the Republic of Kazakhstan. And this is proceedings before the English High Court. And here an ICSID award was issued against Kazakhstan, which subsequently failed to comply with the award. The claimants then sought to enforce it against securities and cash that were held by third parties in London on behalf of the National Bank of Kazakhstan. The claimants here contended that these assets were intended for use of commercial purposes and therefore were outside the scope of the protections of the UK Sovereign Immunity Act. The Sovereign Immunity Act provides that the property of a state is immune from enforcement unless it is intended for commercial purposes. The English High Court in this case found in favor of Kazakhstan and said that pursuant to the Sovereign Immunity Act, all property of a central bank was found to enjoy complete immunity from enforcement regardless of whether the property was used for commercial purposes. And here I wanted to mention that in non-ICSID Convention awards, they are subject to the obligations as set out in the New York Convention, pursuant to which states are obligated to recognize arbitral awards as binding, subject to the public policy exceptions and sovereign immunity. And here it's also useful to mention that some BITs also contain an express obligation that states will comply with the award or carry out an award without delay. Now, the next slide that I want to look at is the enforcement of ICSID awards in particular. So from our perspective, ICSID awards have had a very high rate of voluntary compliance. And in ICSID experience, states have generally complied with adverse investment awards. From our statistics, the outcome of cases at ICSID has been consistently balanced between states and investors. Where they do not get a favorable result, states will often seek annulment. If they do not prevail on annulment, they will opt to pay. You may ask why states may comply with damages awards. In the international investment law sphere, states comply for a number of reasons. First, it comes from a desire to adhere to international rule-based system. Second, because they seek to attract investment. And third, they comply out of reputational considerations. And fourth, due to pressure from home state or from other international actors. Fifth, they do comply to avoid accumulation of interest on award or to appease domestic political structures. So at this point, I wanted to say that non-compliance is actually rare, and non-compliance of an award by a member state is actually a violation of the ICSID Convention and may lead to a dispute between states before the ICJ. Inaction on the part of the state authorities due to the failure to undertake the necessary steps where they were evidently called for are attributable to the state and also attract state responsibility. There is literature that posits that in those circumstances where states have not complied with their obligations, they have done so for political reasons, especially when there is a series of cases involving the same government measure. Here I will refer you to the cases against EU member states in which they relied on the judgment of the Court of Justice of the European Union decision on the ACMEA case as a reason for non-compliance. We've also seen in the past governments espousing investors' claim for the award, as happened in the Argentina cases. So what does ICSID do if a state doesn't comply? Well, ICSID itself, once the award is made, does not get involved in its enforcement. But when a refusal of enforcement is notified to ICSID, the center reminds the party in question of its obligation to comply with an award. So where do you go to enforce an award, you may ask? The most common jurisdiction where enforcement of ICSID awards is sought will usually be in the financial hubs around the world where attachable assets can be found and identified. These are in the USA, and here I'll mention that the most frequent jurisdiction is the District of Columbia, followed by the Southern District of New York. That's one country. And others have gone to France, to the United Kingdom, to Australia, to Canada, to Belgium, and to the Netherlands. For example, in Netherlands, an Air Tanzania bus was grounded by Dutch authorities at Maastricht Airport due to an outstanding claim for an award of 165 million by a Swedish company, Eco Development. Eventually, the plane was released, and the annulment proceedings for this case were discontinued. Another alternative that investors have taken is to monetize the award by assigning rights to the pecuniary award to a third party. Well, in conclusion, I want to say that the autonomous feature of the ICSID convention system and the simulation of ICSID awards to final judgment rendered by state courts provides for a particularly favorable recognition and enforcement regime. It's worth noting here that this regime is unique to ICSID and not available under any other set of rule. In practice, the overwhelming majority of respondent states have to date complied voluntarily with adverse investment treaty arbitral awards. Thank you very much for your concentration, and I will hand over to Noella and the other panelists. Thank you.